My name is Alina Shaltsova. I'm an immigration attorney from New York. And today in our life, we're going to discuss new policies, which are not so new anymore, but they recently became permanent policies of USCIS and Immigration Court. But we actually lived with them for a while now due to the pandemic. And we're going to discuss how those policies are going to affect or may affect your particular case. And of course, in the end, if some of you have questions, I'll be happy to answer them. So welcome. If this is your first time, Alina Shaltsova. I'm a practicing immigration attorney from New York. Please like, share this stream so other people will be able to join us as well. Prepare your questions. Let me know where you're watching from. Hi, Valerie. Hi, Shigal. It's always nice to see you. It's been a while. I had some time off, and now I'm back. And I would like to thank you, all of you guys, being my loyal followers, and those of you who are here the first time. It's extremely nice to see you all. Hi, Ali. Ali watches me every single time, I believe, when I'm live. It's very, very nice to see you. Hi, Imran. And, we're going to start. Don't forget to let me know your questions. Type up, ask your questions in chat. And once I'm done talking about whatever I want to talk about, I'm going to go back, review the chat, and help you guys out a little bit as much as I can today answering those questions. I do enjoy doing that. I think you may benefit from this quick answer. Of course, it's not a full-blown consultation, but sometimes it helps you out just to look into the matter. I can share my thoughts on whatever question you have, and I'm sure it can be helpful. So thank you very much for watching, and let's start. Well, the first new policy, new because it's been around for some time at this point, I wanted to mention would be regarding signatures. So photocopies of the signatures. USCIS at some point in my lifetime, perhaps in your lifetime, did not accept photocopies of the signatures. So we're extremely strict with that. Meaning that if you're filing some application and your lawyer would submit a copy of your signature instead of an original, they would check, I guess, they would take this paper, check. They would send it back. And sometimes, of course, it would cause you great inconvenience, because if an application is rejected, you would have to resubmit it, you would have to lose extra time, and so on and so forth. So during the pandemic, USCIS agreed that they're going to accept copies of the signatures. Great, finally, right? But it's not so simple. What I want to mention here is that, number one, this policy became permanent, meaning that even if you're overseas and you need to submit an application in the United States, you no longer have to mail that application to your lawyer. You can just email an application to your lawyer that was signed, and your lawyer can submit it. In certain situations, for certain types of applications, you can file them when you're overseas. Maybe you're filing for the waiver, for example. So it's extremely, extremely convenient and saves time and money. But remember, it must be a photocopy of the wet original signature. So those signatures that you may have, especially when you type up your name and it becomes a cursive writing, it's not gonna work, guys. Okay? And in fact, USCIS has been rejecting certain applications if they suspect that the signatures that you produced was just a PDF signature and was not a copy of your original signature. Plus, according to the rules, you must save and hold on to that originally signed page, just in case if USCIS would like to examine it. Well, I guess if they suspect fraud, that's when they would like to examine it, right? So it's number one, I believe it's a very convenient policy. And number two, I think it's, it's going to make everybody's life easier. Number three, please don't forget to keep copies of those original signatures. Signatures must be copies of the original signature, so you'll have to print the document, sign it, and then give it to your lawyer. Important to know that. Perhaps for some people it will be useful, right? It may be useful. Now, one more thing I wanted to talk about that's more exciting. Well, exciting maybe for me because I go to court. I take court cases. Internet-based hearings are becoming a norm in immigration courts. All right, guys? So internet-based hearings becoming a norm in immigration courts. All hearings we had this year, individual masters. Person did not have to come into court. And now we have a confirmation, universal policy, coming from EOIR as to how judges should handle those hearings. Yes, is a three-page memo about how judges should handle those hearings, and I'm going to sum up. Basically, it's up to the judge whether to have a hearing by video, any hearing by video or in person. In my experience in New York, currently judges prefer internet-based hearings. You have to be very well organized for that. Why? Because there is no last-minute submission with the internet. The court, the prosecutor, everybody already has to have a copy of what is it that you are going to present in court. Extremely important to know that. Internet-based hearings are more convenient but require more preparation, advanced preparation. So the judge is up to the judge whether or not to have such a hearing. Any party may request such a hearing at least 15 days prior to the hearing, including, for example, your witnesses may appear by an internet hearing. If there is any problem with connectivity, meaning that, let's say a person is trying to get through, is not connecting, so on and so forth, the judge now has to allow reasonable time to resolve this issue. And if not, then the hearing will be rescheduled. If a video is disappearing at some point, the judge will proceed based on audio only. That's important to know that, but I believe only if respondent agrees. There is a benefit for the judge to see you guys. It goes both ways, not only for the judge, but for you. For you, there is a benefit too that the judge sees you, especially if it's an asylum case. Very important, right? So the judges now have this extra obligation to be mindful of problems that may occur when we're having online hearing. But overall, basically, that's going to be a permanent policy. Again, it's going to speed up the cases. Interestingly enough, the memo clearly says that you and your lawyer do not have to be in the same room, which is extremely convenient and may be safe in many respects, especially knowing now that COVID didn't go away, COVID and other things. So that's where we stand with the internet-based hearings. Hearings are going forward for the most part, at least in my practice. They are being handled remotely. And you may know that for master hearings, for example, judges even waive appearance of an attorney. I'm sorry, appearance of an attorney, that would be nice. They waive appearance of a respondent, right? Meaning that you don't have to appear. Your lawyer will have to appear. So that's an interesting change in policy. I think is going to help to reduce the backlog, especially if the hearings are going to be done efficiently. We'll see again what's going to happen, and we'll see what's going to happen, how it's going to go. So far, I have to say I like it, and we're going to move on to our next topic, which is going to quickly talk about what's happening with the prosecutorial discretion. And I decided to include this little little thing about the prosecutorial discretion, just because many people ask me, is the prosecutorial discretion still alive? Can we still use that Mayorkas memo? Well, we can't use the specific memos, guys, anymore. But the prosecutorial discretion is very much alive, meaning that you can use it, you can ask for it, and you should if it's convenient for you, if it's something that you want to happen in your case. Why do I say if? Well, because not USCIS, DHS started on its own moving to dismiss certain cases, guys. And sometimes it's not in your best interest, sometimes it's not what you want. If this is the case, you and your lawyer have to fight for your case. For example, you are someone who filed for your asylum, and you filed with after rather 1 year deadline, and now you're filing for cancellation or removal. In several of my cases, I received scheduling for a special master hearings where the judge, actually it's court's initiative, is looking to get ours and prosecutors take on prosecutorial discretion and potential dismissal of the case. But you see, my particular client does not want the case to be dismissed because they believe they have a strong case both for asylum and for cancellation of removal. And I'm sure some of you are in the same situation where you do not want to be out of the immigration court. You want to proceed with your chance of having your asylum case heard. So be mindful of that. Be mindful that the prosecutorial discretion also still exists. If you do not want to be in court, most likely you will have to submit your FBI fingerprints results before you are granted the prosecutorial discretion. You also probably would like to submit any and all documents in support of your request, showing your ties with the community, showing that you've been paying taxes, that you're a person of good moral character. It's important, but regardless of the fight in court with regard to about the prosecutorial discretion, you still have some of your rights. So it's very important to know that and fight for your case if you do not want it to be dismissed. And now, guys, if you have questions, I'll be very happy to answer them. Hi, Carlos. Hi, Peter. Thank you, Peter. Hi, Leon. I have a lot of you guys saying hello. It's very nice. Hi, Tasham from Pakistan. Hi, Danish. I know for some of you it's morning. We have Friday afternoon in New York. Hi, Tabir. Hi from Houston. I had a PD request accepted by ICE, but it's pending with Board of Immigration Appeals for over 2 months. My IG granted me asylum. IG granted asylum, so was there an appeal by the government? Why was your case in Board of Immigration Appeals? Not really sure. I mean, if the prosecutorial discretion request was just accepted, it doesn't mean anything. Was it granted? Did the prosecutor agree to something? Not sure. But usually, even if the prosecutor agrees to something, Tabir, your lawyer has to make a motion, okay, afterwards. So I'm sure your lawyer is aware of that. And 2 months, I mean, it sounds long for you, but in reality, for courts, it's not such a long time, all right? So I wouldn't worry about wouldn't worry much about the timeline as of yet. Hi, Zulu. Yes, Ali. Yes, I had to take some time off, guys, and I'm very happy that you're all back. We're having a great time. Hi, Saddam. Hi, Lens. Good afternoon. Please like, share the stream. Let's see if some other people would like to join us and have some questions. Hi, Ali. Any update for illegal immigration reform? I'll be honest, every time before I go online, I search the news. I check immigration news clips from American immigration lawyers daily, sometimes twice a day, just to make sure I don't miss anything. But Ali, I have not seen anything good for us yet. Doesn't mean that it's not gonna come. It's just not yet, not yet. Islands from Florida, just not yet. Hi from Saudi Arabia. Let me see. Hi, Mairaj. Is it possible that I think for Pakistani citizen who holds Canadian truck driver license wants to go to USCIS as a truck driver in the United States? You would have to be, if you would like to work in the United States, you have to be sponsored by an employer, guys. Just because you have a license from Canada, it would not automatically allow you to come or work in the United States, okay? Especially if you're not a Canadian citizen. For some Canadian citizens, it's easier to come to the United States and work because they may qualify for something called TN visa, which actually can be applied for right at the border when you're crossing the border. It's very common for Canadians to do that, TN visa. There are certain rules and regulations regarding TN status and visa, but generally speaking, that would be the first option for Canadians, okay? Hi, Kelson. Hi, is it possible to get a green card from a company you're working with? I mean, possible, of course. Usually that's exactly what happens. Company first employs you, they see if you're a good worker, and only then they start the process of sponsorship, because process is can be tedious, meaning it involves a lot of work, a lot of compliance. You have to be on time. You have to be knowing what you're doing. You make a mistake, you have to refile. It's like a very unforgiving process. And yes, it's possible. However, there is perhaps a different question here. And let me guess if this is, can you use experience that you gained with the company that you're working for as qualifying experience during the sponsorship? Usually not. Usually not. And it will be an invitation for a request for more evidence if you will try. Sometimes it's possible if you change the roles in the company, but I would say that as a rule, you have to be pre-qualified for the position you're being sponsored for. And yes, the company that you're already working for may sponsor you. That's how it usually is. I'll be happy to consult you guys if you have new employers, if you have any questions. We do handle employment-based immigration, EB2, EB3 visas. For those who would like to sponsor themselves, there is EB1, EB2 national interest waiver, but not everyone will qualify for it. I have very often I'm asked about EB2 national interest waiver qualifications. Remember, there are several parts for the qualifications. One is to have, for example, necessary education, right? It can be master's degree or bachelor's degree with experience, but then you also have to show a very important point that you're well positioned in advancing certain field. It's extremely important, extremely important. Hi, Kasaga from Uganda. Hi, Siraj. So it's very interesting. I love American, United States immigration law, but it is very complicated and it is changing all the time. So you will have to work with a professional if you're trying to, get some immigration benefits here. Hi, Arham. I applied my asylum in 2016 and still I have not been notified for an interview. It's been almost 6 or 7 years. I'm really frustrated and getting mentally ill. Is there any other way to speed up my asylum case? Thank you for your question. Unfortunately, in the United States, there is a huge backlog for asylum cases. It's gigantic and it's growing. Once I had an interview, once I had a live like this where I shared some statistics about it, guys. Hundreds of thousands of applications are being added to the backlog every year in the United States. And it's growing and it's growing. And if you look at the statistics, only about 30 to 40% of all the filed cases are being called for the interview, meaning that you will probably still be in a backlog for another couple of years, unless you're going to have one of two things done. Number one, you may file to expedite your asylum interview. It has to be a request that is being filed with local asylum office where your case is pending. I believe, USCIS processing such requests as well. So what happens is that you have to demonstrate you have a good reason for it, okay, for expedition. If you are depressed and you can document that, you may have a good reason. And number two, in some asylum offices, not all of them, there is something called a short list. A short list is when somebody cancels and they cancel on a short notice, and then USCIS is going to call you for the interview instead, but you have to be absolutely prepared, okay? So whenever you want to expedite your case or request that you will be added to that short list, first of all, prepare. It's extremely important. And then ask for your case to be expedited, because if your case is just a shell, there is no statement attached, no evidence attached, you don't have updated country conditions, you will get a denial. You have to prepare, okay? Hi, Narayan. Is there any update on aging out kids for legal immigrants? We already filed I-45, UB3, yes. I know that there were several attempts to promote legislation helping children of legal immigrants, those who are aging out. But to my knowledge, nothing yet has become the law, okay? So just a bunch of proposals, nothing yet became the law. And yes, it's a very frustrating situation. We're talking about children of somebody who, for example, was on H-1B or L-1 visa and now is being sponsored by an employer. The father, mother may proceed with the sponsorship or with their green cards, but children who are over 21, and if they're not saved by Child Status Protection Act, will be aged out and they will lose status. Usually such children will try to jump to a F1 visa if possible, right? To change status just to maintain it, to become students. But of course, maybe something else depending on the situation. And we're going to take the last question. Hi, Tridona. Can I close my asylum case if I have a U visa pending in TPS? Somebody who filed their asylum case, that person has a right to withdraw it. Whether or not it will be the best possible situation for you, I do not know. But you may withdraw it if you want to. Just remember that if you do so, you most likely will lose your asylum 1 year deadline, right? And in the future, if you would like to renew your request for asylum, it will be extremely difficult on the same facts to qualify for it. But if you want to give up your asylum, yes, you can. Yes, you can. Well, guys, thank you very much for watching. It was a pleasure. Thank you for having me in your life for almost 30 minutes. Please like, share this stream. Don't forget to come back next week when hopefully we're going to have some more exciting news to talk about. And again, Alina Shaltsova, immigration attorney from New York. You can find me on my website. You can call our office if you need a consultation. The numbers and information is at the bottom of the screen. And I hope to see you soon.